Welcome to Will's Trust and Estate Planning Problems and Solutions. We've got a live event. It's going to be recorded, and you can watch this webinar and learn about Will's Trust and Estate Planning Problems and Solutions. You see, so many people put off this. They procrastinate the decision to get this done. They say it costs money, it takes time, I don't want to think about death, I've got other things, I need to spend more time planning for my vacation than my kids or my life savings, right? But don't you want to make sure that your life savings goes to the right people at the right time rather than to the wrong people or to the right people at the wrong time, right? It's time to stop procrastinating and make sure you get it done. Let's learn. Let's go through here. Let's identify. Really, it's potential solutions. Yes, I'm a Texas attorney. I'm Mike Massey. I own a law firm, Mike Massey Law. I have 4.5 college degrees. I have 5 kids, a wife of almost 20 years. And I love presenting information. So I hope this is valuable for you. This is not legal advice. Don't take it as legal advice. This is just to get your wheels turning, to contact your attorney, to get your estate plan in order. If you live in Texas, I would love to have a conversation with you. So let's get going. Let me share my screen. All right. So let's talk about some problems with the old way of estate planning. Let's say you have a blended family. Dad dies. Kids get the money. His spouse's assets get cut by almost 50%. That could be a problem in some situations. Another scenario, spouse inherits money, gets remarried, right? So the blended family still, spouse gets it, gets remarried, leaves it to the new spouse. So the kids of the deceased spouse get $0. That could be a problem. Let's say spouses own a home jointly. Husband dies. Does wife automatically own 100%? Typically in Texas, the answer is no. Why? Because most houses, I would venture to say 99% of houses are not owned as joint tenants with the right of survivorship. The default in Texas is typically almost always tenants in common, which means the husband owns half, the wife owns half. When you pass away, the estate owns the deceased person's half. Another scenario, your child inherits $500,000 in a lump sum at 18 years of age. Wow, what could possibly go wrong, right? That's throwing fuel on the fire. Another scenario, your child has a drug alcohol addiction and inherits $500,000. That will fix their addiction problem, right? I don't think so. You die, your relative gets your children, relocates them, and has different religious beliefs and values. Is that what you want? Is that who you want raising your children? Another scenario, your LLC has employees. It's valuable and you die. Who can pay the employees? No one until they get, if they don't have the power to do it, which in a lot of LLCs and small businesses, no one else has the power to do that, right? To move money around bank accounts, write checks, do all that stuff, run payroll. And if the employees can't get paid, they're going to leave, and that whole business just, the goodwill, the value, the blue sky evaporates overnight, and that business is gone. Not all the time, but in some small business and LLC situations. So be careful. The state of Texas wrote your default estate plan, but you might not like it. So some people are like, well, it'll just go according to law. Yeah, but it might not be the way you want. And again, if you have money or even life insurance, then they could get all that money at 18, which is a really young age to inherit a bunch of money. Okay, right here. Probate is fine if you don't mind fees, time delays, and publicity. Do-it-yourself online wills might work, or they might not. It's only your life savings. Child number 1 wants to pull the plug on you, but child number 2 does not. What do you do, right? That's a complicated situation. Now you've got the court that needs to get involved, and that takes time and lots of money. All right, child number 1 wants to cremate you, but child number 2 wants to bury you. What'd you do? You didn't sit around and talk about that at Christmas dinner and Thanksgiving dinner. So now they're disagreeing on what you wanted, and maybe you never specified it, but you have a strong opinion one way or another, but you can't state your opinion anymore. Blended family disinheritance issues are prevalent. Why? Because we live in a 50% divorce rate society. Look here, you failed to update your beneficiary designation, so you left money to the wrong person, the wrong child, to a sibling, to an ex-spouse, something like that. That is problematic. Your home warranty deed is almost always inadequate as an estate planning tool. We'll talk about that. But don't worry, there's a new way of estate planning, right? A lot of this is the old way of estate planning, the problems, the stress, the do-it-yourself, the not understanding blended family situations. Let's talk about some potential solutions. You can go, if you live in Texas, you can go to bit.ly/Texas lawyers meetings. So all those words end in an S, Texas lawyers meetings, bit.ly/. There's no .com. And you can book a free consultation with one of our Texas attorneys who can talk to you about your Texas estate plan. We can't give advice during that, but if you like what we have to offer and we're a good fit and we think you're a good fit for us, then we'll extend an invitation to come aboard and sign an engagement letter and pay our retainer. Intestacy, what is it? It is dying without a will. You never did your last will and testament. So the state does have an estate plan that's already designed for you if you don't have one for your own. What's the problem? One, it's more expensive. More attorney's fees, more court fees. Two, it's more complicated and it takes more time. Three, potentially disinherits the spouse if it's a blended family situation. There's kids from a prior relationship. Kids inherit everything on the 18th or 21st birthday because you didn't set up some kind of a trust or subtrust inside of your will or trust. So what happens if they have a problem with drugs or alcohol or creditors or relationship problems with their spouse? These are things you could have taken care of ahead of time, but you didn't. You died intestate without a will. And now the state of Texas decides what happens and when they get the money. And it's very well may not be the timing or the people that you want it to be. Solutions. Do proper estate planning right now before it's too late. Probate. What is it? It's the process of proving your will in a court of law. Problem. It's expensive. It's time consuming. There's a potential for probates in multiple counties and or states, right? What if you have property in different states? Well, now you've amplified the time and money and expense and process that needs to get involved. It's a public process, so everybody can look and see what you were about, what assets you own potentially, and seeing your net worth. That could be bad for hackers, for nosy friends and family, etc. And that one, all right. They get to see your laundry, both your clean and your dirty laundry. It's open to the public, right? Many states are far more expensive and time-consuming in Texas. Right now, as I record this, in Texas, it doesn't take too long, and it doesn't take too much money. That could change at any point in time. We could become the next California, New York, pick your state, where it can take a lot longer and a lot more money. So just because the process is one way right now doesn't mean it's going to stay that way. You may not even live in Texas when you die, right? Maybe you move near your kids, which happens a lot to aging parents, is they'll move out of state to another near to their child or one of their children, and they won't update their plan. And so now, again, you've got issues going around. And you must involve attorneys in the court system. In Texas, for probate, you have to hire an attorney. You can't do it on your own. Solutions. Do proper estate planning right now before it's too late. You're going to hear that broken record. I'm going to say that over and over and over. All right. Doing it yourself, DIY online will. What is it? Well, you save money potentially by doing it yourself, but what's some of the problems? You might do it wrong. It could increase the chance of litigation. Ooh, big one. You think anybody might fight over your estate? We see estate fighting all the time, even in families that get along, because you know what happens? Money, greed. Money causes greed, and greed causes people to lose their senses. They stop being nice, they stop being friendly, and they just start getting into it because they want anything and everything they get their little mitts on. And what we find with a lot of do-it-yourself is they're often not properly executed, either the signature, the notary, or the witnesses. So we'll see. I can't tell you. I mean, I've probably seen this 100+ times where people show me, they'll walk in and they'll say, here's the do-it-yourself will that I did online and I saved money. Will you review it? And I'll say, when did you do this? 6 years ago. Where's the original? Oh, that's the original. You never signed it. There's nothing valid about this. You never signed it, or you signed it without a notary or witnesses, right? Did you have the self-approving affidavit afterwards, which is going to help with the probate of that will? And this gets missed all the time. You know, it's hard to think through the various scenarios for your unique situation when you don't do this all the time. You do it once or twice in your life and you're not thinking through it. Well, we get to see this every single day. So we get to think through these situations. Real estate, what happens with that, with the business, with children with addiction problems, with children with marital problems. Is it a blended family? What happens if you leave it to the surviving spouse, but then she disinherits the children? What if you just leave it to the children, but now that surviving spouse doesn't have enough money to live on, right? We think through these issues. What's the solution? You guessed it. Do proper estate planning right now before it's too late. Blended families, what is it? Spouse has a child from a previous relationship. Sometimes just one of the spouses, sometimes both spouses. Problems. Number one, no will. Let's say children inherit the majority of your assets, not your spouse, right? So there's a difference between community property and separate real property, like real estate. But we're just going to go very simple. Let me give you an example. Let's say you have $1 million investment account and you were married before and it was community property. Well, when you pass away, generally speaking, your half, let's call it $500,000, goes to your children, not to the spouses, not to the spouse. So let me put this another way. Let's say you're the spouse who survives and your spouse dies and half of the estate, $500,000 goes down to, let's say, his children. So you're only left with the $500,000. You literally got your assets cut in half overnight and now you've got half the money to live on. Maybe that's what you want. Maybe it's not. But a lot of people don't think about that because they're not thinking about this. Number two, will 100%, let's say the will says 100% goes to spouse. So you pass away. So let's say we're the dad now, the husband. Husband passes away, gives everything to wife. Wife then gets remarried. Her next husband doesn't have a whole lot of money. So she's like, I don't want him to be destitute. He needs money as he's aging. So I'm going to leave him everything, not the kids of my former husband. Now the kids of the former husband get nothing. Is that what you want? Some situations it is. I've seen that actually happen in my own extended family. Number three, will 100% to the child to care for the spouse. So I've seen this. Husband comes along, says, spouse, wife, I'm going to give my half of the estate, my $500,000, for example, to my child. And he's going to use it to care for you. That way he'll have the money. He'll be able to invest it. He knows how to do it. It'll just make it really simple. And then he's going to give you money. Well, here's what could potentially happen. It could go potentially right according to plan. That child is great with money, invests it well, shares with stepmother till the day she dies. But here's some things that could go wrong. The child says, I need this money. I don't want to help stepmom anymore. Or stepmom's mean to me. I don't like her, so I'm just not going to give her any more money anymore. Or she goes into a nursing home. She doesn't need it anymore. Government's paying for her. I'm just going to keep this for myself. Or that child gets a divorce or gets sued from a slip and fall on their property or a car wreck or something like that, and gets sued for millions and loses all this money to their creditor. Now there's no money left to share with mom because the money went to that child's creditor. So all these things you got to think through. Child and step-parent, part 4 here. Child and step-parent don't get along. Child says, you can't see the grandkids. So guess what? The step-parent cuts them out of the estate. So that's a scenario where, let's say husband passes away, leaves it all to wife, thinking, oh, my wife loves my child, her stepchild, and she's going to leave everything to him. But then there's some kind of falling out between stepmom and stepson, and stepson says, you can't see my kids anymore. You know what? I only put up with you because dad was alive, and out of respect for him, he's not here. You can't see the kids or your grandkids. And so she says, fine, I'm changing the beneficiary. I'm going to leave everything to Little Red Bird Foundation or to John Sample, right? I'm not going to leave anything to you. That's all right if it's her money at that point in time. What's the solution? Do proper estate planning right now before it's too late. Durable power of attorney. What is it? This is if someone is incapacitated, it states who can make important, namely financial decisions for you. Let's talk about some problems. You get in a car wreck, have a coma, head trauma, stroke, dementia, Alzheimer's. That's where this really comes into play. Because who will pay your mortgage, your taxes, your bills, your groceries if you don't have anybody named who can do this? So then you got to go and get a guardianship proceeding, go through the court system. You got to have an attorney, court fees, time, very expensive and ongoing process. Banks, let's say banks won't allow a non-agent to transact on your behalf, right? So why would a bank listen to your spouse or your brother who may not be on that particular account? Let's say, no, it's only your account and you have Alzheimer's, dementia, you're in a coma or something, and your brother or your spouse comes to the bank or the investment company and says, hey, I need to write checks. I need to change out of this investment that he was in because this blah, 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 stocks, bonds, whatever. And they're like, who are you? Well, I'm the brother. I'm the spouse. Well, do you own the account? No. Is your name on it? No. Do you have a power of attorney? No. Do you have guardianship over him? No. Well, then we can't take any direction from you. Go hire an attorney, go through a court, get appointed as a guardian, come back in, 3 to 6 to 9 months. And then we can, when you have the right paperwork, then we can do something. And you're like, but this needs to be done now. They're like, sorry, you don't have any power, right? What could potentially happen? Foreclosure, late fees, penalties, right? Tax filings, real estate, all that stuff, not getting paid. Can't change investment allocation, risk. What if there's a downturn in the market? What if there's a depression, et cetera? What if you appoint the wrong person and they steal your money or self-deal, right? When you appoint an agent, you want to look for a lot of things, but two primary things that I encourage people to look at are: one, choose someone who is honest. I mean, honest as a day is long. And number two, they've had experience managing money well, their own money, right? They don't have to be wealthy. That can be helpful, but they at least have to be responsible with money, having made good financial decisions. That's my opinion. Because why would you want to appoint someone you don't trust? And why would you want to appoint someone who you do trust, but they've made bad financial decisions, right? Everything they've invested in hasn't turned to gold, but turned to muck. And they've had multiple bankruptcies or something like that, right? So you want to be thoughtful about who you appoint. What's the solution? Get a durable power of attorney in place right now before it's too late. Medical power of attorney. What is it? If you're incapacitated, who can make medical decisions for you, right? If you can make your own medical decisions, you're going to make them. But if you don't have the ability to make those medical decisions anymore, then this is going to give that next person, we call them an agent, the power to make that decision for you. Very similar to what we just went through: car wreck, coma, head trauma, stroke, dementia, Alzheimer's, etc. Who can make your medical decisions for you if you cannot, if you don't have one of these powers? There could be a fight amongst the spouse, child number one, child number two, and your siblings. The spouse says this should happen. The brother or sister says this should happen. The parent says this. The child says this, and they're all fighting. No, dad needs this type of care and this and that. Really? And you don't think it could ever happen? It's happening all around you right now. So get a medical power of attorney in place right now before it's too late. Remember, you can book a free consultation with the Texas attorney if you live in Texas. We'd love to talk to you. We'd love to have a free consultation, get to know you. If it's a good fit for us, we'll extend an invitation to hire us by signing an engagement letter and paying our retainer. Until all of that happens, you are not a client of ours and we are not engaged. And this is not legal advice. This is just information that you can kind of start thinking about things so you can go talk to your attorney to help. But if you want to book a consultation and you're in Texas, click, well, not click, you can't click here, but type in bit.ly/Texas lawyers meetings. Those are plural. bit.ly/Texas lawyers meetings. All right. Kids power of attorney. What is it? What if you're incapacitated or unavailable? Who can make important medical decisions for your minor child and complete certain daily tasks? What's the problem? You're like, why would I be incapacitated or unavailable? Let's say you have a car wreck. You're in a coma. You have a head trauma. You have a stroke. So you're in a bad car wreck. Who can tell the doctors what to do on your child? Since you're in the hospital room down the hall and incapacitated, right? Y'all are both in a wreck. Who's going to tell the doctor what to do? Well, this power says what agent has the ability to make that decision for the child while you're incapacitated or unavailable. Another scenario, let's say you're in China, India, Mexico, wherever, and travel ceases for the time. Oh, that would never happen. Really? Well, we've seen it happen with COVID. Airports, airplanes shut down. Trains, planes, and automobiles, right? Hard to get places. We've seen shutdowns in Afghanistan. We've seen shutdowns in a lot of different countries where you just can't get out for a period of time. Maybe ever, maybe just a period of time. But if you're incapacitated, but a court has an appointed guardian for your children, who's going to make these decisions? You're on vacation, but your child gets rushed to the hospital from home. Who has the ability and authority to talk to the doctors about what to do with this document? They actually have that legal ability and authority to do that. So what's the solution? You got it. Do your estate planning. Get your kids' powers of attorney in place right now before it's too late. Setting up beneficiaries for failure. So what is this? This is beneficiaries inheriting money at the wrong time. Everybody says, well, if I get it going to the right person, that's great. Okay, let's walk through some problems. 18-year-old inherits $500,000. What could possibly go wrong? This is the most incredible thing. Wow, I wish this happened to me. No, I don't. I'm glad I have my parents, and I still do. If you are 18 years old and you inherit $500,000, $1 million, $5 million, do you think you would have made great decisions? 95% of the people that I talk to, I'm making up that percentage, but it's a very high percentage, say, that would have been bad for me, right? They're like, I was struggling with alcohol, drugs, peer pressure, just spending, right? If mom and dad gave me money for lunch or whatever, I used it for this. And if they gave me money for this, it was, you get the idea. Just bad decisions. Frontal lobe hadn't come in fully. So what could possibly go wrong, right? You've got peer pressure, addiction, relationship, bad business decision, creditor from a car wreck or a house party, right? They go out and have some drinks, get in a wreck, get sued for $5 million, lose everything, including their life savings, because they got it at 18 and not at a later age. Take another scenario. 40-year-old child who's addicted to drugs or alcohol inherits $500,000. Will that fix their decision? Is money the answer to their problem? I've never seen an addict where money answered the problem, with the exception of that money paying for rehab that helped get them on the right track. So money, my opinion, usually is throwing gasoline on the fire when someone has an addiction. So even if they're grown up and you're like, my kid's 40. Yeah. But if they're addicted, that can be fuel to the fire. And then that just actually makes it worse. Think about it. What if your kid's 40 and doesn't have a present alcohol or drug addiction or some kind of other addiction, gambling, spending, whatever, but they used to? And then it comes back and they get all this money and all that money's gone. It's another thing that you can consider thinking about. Let's say a well-adjusted child inherits from you, then commingles the money, then their spouse files for divorce. Whoops. Looks like ex-spouse could have a great payday. States are different. In Texas, generally, when you inherit money, that's generally considered separate property. When you commingle it into commingled real estate or commingled investments or commingled bank accounts, then you got an issue if there's a divorce, right? We're not going to go into say how much or what specific is separate properties and community properties, subject to divorce proceeding, all that stuff. But suffice to say that if you commingle money, which a lot of people do when they inherit it, I would venture to say, well, I won't say a percentage, but a lot, based on what I've seen. And then there's a divorce, they could potentially lose a significant amount of that inheritance. So you want to be careful with that. What about leaving money to a special needs child, disqualifying them from government assistance? So a well-meaning grandparent says, hey, I've got this grandchild and they're special needs, and I want to leave them, 50% of my estate to take care of them. I'm going to leave them $1 million. Well, you leave them that $1 million, and now they're making this number up. The $50,000 a year they're getting in government assistance goes bye-bye. And they've got this because they've got too much income, right? Too many assets. So they're not qualified anymore. So until they burn through all that money, they can't get qualified again. There's better ways to leave money to a special needs child or grandchild or just a special needs person. What's the answer? Get proper estate planning in place right now before it's too late. All right. Blended family subtrust. What is it? It's a trust to hold a decedent's estate. And let me check something. All right. Generally speaking, surviving spouse has some access but cannot change or disinherit the beneficiaries, so descendants' children have protections in place. What's the problem? Say John leaves 100% to Janie. Janie gets remarried to Pablo. Janie leaves everything to Pablo, and John's kids get 0. Another problem. John leaves 100% to his kids to take care of stepmom Janie. Kids decide to give her $0. Janie is SOL, spouse, out of luck. I know where your brain was going. No, we don't curse. All right, number 3. John leaves 100% to Janie, but John's kids don't like Janie, so they don't let her see grandkids. So Janie, we talked about this earlier as an example, disinherits them and leaves them $0, et cetera, et cetera. The sad stories are endless. I hear them all the time. I see them. I've seen them in my own extended family several times, at least 2 times that come to mind, and huge dollar amounts. We're talking 7-figure dollar amounts. So you want to make sure to consider a blended family subtrust. There's different names for it, but talk to us and we'll see what might be good for you. Get proper estate planning in place now before it's too late. All right. Kids trust. You can call it a strikeout trust. That's what we like to often call it at Mike Massey Law. They could be known as inheritance trust or inheritance trust or generational trust or whatever. Lots of different names. Doesn't matter. What is it? It's a trust to hold children's inheritance. Generally speaking, the kids get the money over time rather than all at once, say at age 18 or something like that. What's some problems? Kids inherit money and lose it to divorce, immaturity, bad decisions, peer pressure, gambling, drugs, alcohol, etc. What are some solutions? Potential solutions could be get a kids trust in place right now before it's too late. It might look something like this, right? HIMS, you'll hear this term thrown around the estate planning world. Health is for H, or H is for health. E is for education. M is for maintenance. S is for support. Health, education, maintenance, and support. And then maybe they'll layer on top of that, when they're 23 years old, start giving them 5% a year every year, as long as the trust is around after that. And then again, these various ages and stages and percentages can all be different. You talk to your attorney about what's appropriate for you. This is just one, kind of throwing out a random example. Maybe at 25, they get an extra 30% of what's there. At 30, they get 0.5% of what's remaining. And 35, they get the rest, right? You can play with these ages. I've seen people push it out for the lifetime of the beneficiary because they'll never be able to handle that much money inherited based on, addictions, spending issues, money issues, whatever in some situations. Some people push out till 40 or 50 years old or whatever, different percentages. You talk to your attorney about it, but we're just trying to get some ideas in your head to think about. All right. Book a free consultation. You can go to bit.ly/Texas lawyers with an S, meetings with an S, bit.ly/Texas lawyers meetings. That'll get you right to our booking page. You can book a free consultation. We'll ask you to fill out a questionnaire after you book that before the meeting so that we have a good idea of what's going on in your life. And presently, we offer a very nice discount for filling that out as well. Revocable living trust. What is it? Management and distribution of your trust assets upon your incapacity and or death. Problems. Well, it costs a little bit more than it will to create typically. And you need to fund it. Make sure your assets are properly titled, whether you're titling in the name of the trust now or you're naming the trust as the beneficiary upon your death or your spouse's death. What are some of the potential benefits? Privacy, right? It's private, not public. Avoids probate. A trust avoids probate, but you still have to make sure your assets are titled to avoid probate to go into the trust or to go to a direct beneficiary. Otherwise, they'll become a probate asset, hit the will, get poured over into the trust if you have a pour over will. Another benefit is incapacity provisions. So if your assets are in a trust and you become incapacitated, then the trustee begins to manage those assets. If they're not in the trust and you have a power of attorney, then the power of attorney for your durable power of attorney, financial power of attorney, will make those decisions. But usually I would argue from what I've seen that a trustee has an easier time managing assets than an agent for a power of attorney. Sometimes some institutions can put up a little fight or be tiffy when it comes to a power of attorney, whereas with the trust, they usually have, from what I've seen, just kind of superior, better, or powers are more able to kind of function with less resistance than a power of attorney. It's more flexible than a will. For example, you can have an exhibit B for backup beneficiaries. That's what we like to do in some of our trusts, because the backup beneficiaries may not change. Primary beneficiaries may stay the same, right? It's like, it's my kids, grandkids, something like that. But the backup beneficiaries may change. It's like, well, what if you and your kids pass away in a car or plane accident or something? They're like, well, right now I'd want it to go to my parents. Well, what if your parents aren't there? I'd want it to go to my friend. What if your friend's not there? I'd want it to go to this charity, right? So we can make a backup exhibit for that you can just update, change those backup beneficiaries very easily without changing the whole trust. So that's one of the things that can be flexible about how we specifically tend to design some of our trusts. If you own an LLC or properties other than your home, then it's a really good idea to consider a trust, because again, the LLC is typically outside of the operating agreement. Usually the operating agreement is either silent or says it's, you can pay it out to the estate, which means like the executor of the estate would have that power for the benefit of the estate. But then you got to wait on a probate court to get that going, to appoint those letters testamentary so that the executor is actually nominated and can go out with those powers. And that can actually really hurt some businesses if they're having to wait on a probate court. And what if you own assets in other states? That's where a trust can really come in handy, because if you don't have that, then you're potentially looking at probate in each of those states, which can be very time consuming, costly, and just problematic. So kids nomination for guardian. What is this? If you die, leaving minor children behind, who will raise your kids? Well, a problem. State has a default plan for who will raise your kids, but that person may have been your last choice, right? They name your sister, but you know that your sister, I'm making this up, is verbally abusive, is physically abusive, is just a bad person, is mean, is always pessimistic, and never makes good choices. But the court decided to appoint her anyways because they didn't know all that, right? Put this in writing beforehand. This is one of the biggest things. People are like, I need to get my estate plan primarily for my kids, but why haven't you gotten it done? Because I can't decide who I want to be named as the guardian for my kids. Well, name someone, because even if you're trying to name someone to avoid someone, right? And you can certainly put in those documents, or we do in ours, if there's someone you don't want, right? Saying, I never want my sister Sally, my brother Bobby to be named as guardian of my children, right? Tell the court that in advance. That's one thing to do too. Who should these people be? You want to consider religious beliefs. Maybe you want someone with similar religious beliefs raising your children. Geography. Are they going to uproot your children and take them to another state or another country? So that's something to consider. And I have many clients who are like, yeah, I want my kids to be raised by my sister in Virginia or my parents in India or something like that. So for some, that's great. And for others, that's not. Values, do they share your values? What about political outlook? What about ability and desire, right? For aging parents type situation. What about marital situation? If there's a potential divorce, do you still want them to go to that family if that, two people that you name who are married are no longer married? What then, right? We can talk about that. So get your kid's nomination for guardian in place right now before it's too late. All right. And prenatal guardianship. If you're incapacitated, this is naming who you want the court to appoint as your guardian. So if you have medical power of attorney and durable power of attorney, this probably won't come into play, but it's still nice to have as a backup. Because if someone starts stealing, taking advantage, there's dementia, Alzheimer's issues, and you start writing checks to so-and-so, well, you can keep opening up a bank account in your name and sending out money. So you may need a guardianship by a court, and this is where that type of stuff comes in. So what could happen? What if there's a car wreck, coma, head trauma, stroke, dementia, Alzheimer's? A POA may not always be sufficient. What if there's a rebel child who keeps taking advantage of mom, writing checks to self, using ATM card, going to bank to make withdrawals? I've seen this. Rebel child keeps having mom execute a new will and new powers of attorney without the knowledge of siblings and revokes the prior documents. Now you've got a whole giant headache. So this would necessitate probably a guardianship situation. So don't you want to say in advance who you want that guardian to be? Solutions: get the preneed guardianship in place now before it's too late. All right. Living will, also known as advance directive or end of life initiative or pull the plug. So what is it? Well, here's the problem. If you're in a terminal or irreversible condition without capacity and are only alive because of artificial life support, then what? Let the courts decide? Let the doctors decide? Let your agent decide? Tough decision, don't you think? Should we pull the plug or not pull the plug? Because this literally means life or death for this person. Pull the plug to reduce suffering and hospital bills. Maybe they want to pull the plug because they want you to die so that there's no more hospital bills so that they can inherit more money. That's one thing to consider. What if they keep you plugged in, and you might recover miraculously? I've definitely heard of stories of clients talking about this where so-and-so was supposed to die and they unplugged and here they are 17 years later alive. They made it through it, right? God can work through that. God can also, he's sovereign, does what he needs to do. Whoops, going the wrong way. All right, HIPAA release. What is it? This names the people who have access to your medical records. Again, what if you have a car wreck, coma, head trauma, stroke, dementia, Alzheimer's? It's difficult to make proper decisions without proper medical records. So get a HIPAA release in place right now before it's too late. Final disposition instructions. This states your preference for burial or cremation plus specifics. Because do your kids or friends know which one you prefer? Right? You might have a strong preference, yet no one knows about it because you didn't talk about it at Thanksgiving or Christmas or while you were watching that football game or had the family reunion. What could possibly go wrong? Child one fights with child number two. Religious beliefs. Splurge versus thrifty, right? One wants to splurge and give you this, $40,000 cemetery and casket and headstone and all that. One's thrifty. They're like, nope, green burial, burn, cremation, ashes, $200, we're out, right? Religious beliefs. Some say, well, no, mom or dad was XYZ religion and they forbid burial or they forbid cremation, right? And you've got this problem. What if one says store the ashes, but the other one says spread the ashes? They agree on cremation, but then they're trying to figure out what to do. One wants the ashes on the mantle and one wants them spread in the sea, ocean, around a tree, in the air, whatever, in the mountains. That's a problem. Go ahead and say this in advance. Why? Why not? Get your financial disposition instructions in writing now before it's too late. Beneficiary titling. What is it? This is naming a beneficiary on your accounts like a TOD, transfer on death, or POD, payable on death. What are some of the problems? All right. So let's say you named a beneficiary with the POD or TOD. What if you name the wrong person? Right? You name someone, but then you get divorced from that person. You name your daughter, but then you'll have a falling out and you left her in there. You named your sister, but then you got married and you forgot to update that to name your wife, right? These are all problems, and we see these all the time. What if you named someone who's deceased? You named someone, you named your sister and they're gone. You named your wife and they're gone. You named a child, but they died before you. What then? It could be problematic. What if you named your ex-spouse? Ooh, we see this all the time. You've got to be super careful with this. What if you only named one child? Happens all the time, thinking they'll share with the others. So mom comes in and she says, hey, I've got 2 children. I'm leaving it all, or 3 children, let's say. I'm leaving it all to child number 1. They're the oldest and most responsible. The other 2, whatever. I'm just giving it to number 1. Then they can divvy it up amongst child number 2 and number 3 because that's easy. Let's talk about some potential problems. 1, child 1 gets in a car wreck, inherits this, let's say $3 million. All examples, very random examples, $3 million. Wanted to give $1 million to the other kids, but got in a wreck the next day and lost a judgment for $5 million. All $3 million goes to that creditor. You have, the child 1 has none, child 2 has none, child 3 has none. Another one inherits $3 million and then decides, because they're a nice and honest person and no mom's wishes, decides to give the $1 million to each of the others too. Ooh, that's above the gift tax limit. So you got to file a gift tax return. You may even have to pay gift taxes on it, depending on what the tax laws are at the time. Right? Lots of issues. What if it's an IRA? How are you just going to pull the money out in an IRA and give that to them? Right? Don't do this. Don't leave all your money to one kid thinking they're going to share it to with the others. Another scenario, leave it to that child 1. Child 1 dies, and their estate goes to their spouse, let's say. So their spouse gets everything and doesn't want to share with child number 2 and child number 3 of their now deceased mother-in-law because they didn't really like the siblings, the brother-in-law and sister-in-law, right? Problem, we see it. And do you do per stirps or not, right? You want to understand what per stirps and per capita is. So get proper asset titling instructions right now from your attorney before it's too late. Book a free consultation. You can talk to one of our attorneys. Go to bit.ly/Texas Lawyers Meetings, bit.ly/Texas Lawyers Meetings. We'll have a free consultation. And if we think it's a good fit for you and for us, we'll send an invitation to hire us by signing an engagement letter and paying our retainer fee at that point in time. Asset titling. What is it? How are your assets owned and who are the named beneficiaries? Some problems. Do you have it titled as joint tenants or joint tenants with the right of survivorship? They have very different outcomes when you pass away. Generally speaking, joint tenants means you own half and your half goes to your estate when you die, whereas a joint tenant with right of survivorship goes entirely to the other co-owner of that account. Very different ramifications. Home ownership in Texas defaults to tenants in common instead of joint tenants with right of survivorship. So the wife only owns half the home when the husband passes away. And that means probate is necessary absent a TOD. Might even disinherit the spouse, leaving only a life estate, right? So if it's a homestead in Texas and the surviving spouse has gets a life estate but doesn't actually own that half of the property because the half went to the deceased spouse's former children or children from a different relationship, something like that. Right. So everybody comes in, not everybody, a lot of people come in. They're like, well, we own our home together. Yeah. And if you don't do anything about it, it's almost certainly going to go through probate when the first spouse dies and then probate again when the second spouse dies. 2 probates. Hiring attorneys twice, paying probate and court fees twice, waiting on the whole process twice. What if you make the child as a joint owner? Well, we've seen this. Mom comes in and says, I'll make my son a joint owner with me and they'll own it upon my death. Well, potential issues with gift tax and creditors, right? Because if your son owns it, that portion's probably not going to get homestead exemption for creditors. So if that person gets in a wreck then there could be a creditor potentially leaning on that. And if you just gave them half of your house and it's $1 million a house, you're supposed to talk to your CPA, but they may actually say, in some situations, a gift tax return needs to be filed, and maybe even gift taxes paid, depending on all the gift tax stuff. We don't give tax advice on this. So just take this as something to think about. Go talk to your CPA and your attorney. And again, if you made your child the asset on co-owner on that asset, that home, for example, or a bank account, we see this on bank accounts all the time, then you just may have disinherited your other children from the asset. So you name your child as joint tenants with right of survivorship. So you pass away, that child owns everything. And let's say, and a lot of times people say, well, it's just a bank account with 10 grand. It's not a big deal. Well, what if right before you went into that nursing home, you sold your home, very common, and now and you liquidated your investments, and you've got $1 million, $2 million in that bank account, and it's co-owned with your child. You've got gift tax issues, potentially income tax issues. You've got disinheritance issues. You've got creditor issues. That child gets in a wreck. All of that money, or at least half of it maybe, potentially subject to their creditor. And then when you pass away, they own it all, so they don't have to share it with the other kids. And if they decide to share it, then again, we've got this whole gifting, in gift tax return, potential gift taxes in play. Talk to your attorney, talk to your CPA. If you become a client of ours, we can talk to you about some of these things to help you think through them, and can always, go from there. So get proper titling asset instructions right now before it's too late. Let's look at some home ownership problems. Who owns your home if you die? This is the number one mistake that I see that triggers and causes probate. Problem. Home ownership in Texas defaults to tenants in common instead of joint tenants with right of survivorship. We just talked about this. So let's say the wife only owns half the home when the husband passes away. Probate necessary absent to Todd, may even disinherit spouse. Another issue to think about is the cost basis step up or not, right? This is for your CPA to talk about, but depends if it's community property or separate property. In community, if it's community property, talk to your CPA. But generally in Texas, a lot of things that are community property may be entitled to a double step up in basis under current law, where you get a step up in cost basis on the first death, a step up in basis on the second death. But if it's separate property and it was not considered community property, then a very different scenario. So some of our clients who have separate property may decide to commute it to community property for step up basis, tax basis purposes. But they're also putting it into the reach of that new co-owner's creditors, and also subjecting it to being split up differently in a divorce proceeding. So you got to think through these things. So get proper asset titling instructions right now before it's too late. Talk to your attorney or book a meeting with us so that we can talk about some things. Most Texans should have 2 deeds per property. 2 deeds. I'm a Longhorn. 2. What is it? A warranty deed in your name does not help you avoid probate. Again, husband and wife, defaults to tenants in common, not joint tenants with right of survivorship. So I don't know, in my career, I've seen maybe 5 clients, I think, less than that, probably, certainly less than 10. Quick thoughts in my head, who've ever had joint tenants with right of survivorship listed on their deed. For everybody else, we go through these issues we've been talking about in the prior slides. So what's a potential solution? Consider adding a second deed to your home, like a transfer on death deed or a ladybird deed, or deeding it to your trust presently, right? Those are 3 core ways that we will do: transfer on death deed, ladybird deed, or warranty deed to your trust now. Converting home from separate property to community property. What is it? You have a decision to make if you own your home as separate property. Do you keep it as separate property, weighing divorce implications against death tax considerations, or do you convert it to community property? Again, weighing those against each other. Speak with your CPA, speak with your attorney. But if you're in Texas and you become a client of ours, then we can have that discussion. or talk to your family law attorney and CPA regarding the separate property and community property and taxes and divorce situations and stuff like that. LLC while living, what is it? We want to have a discussion, right? You want to think about LLCs. So liability exposure. What if there's a slip and fall on that property, like a real estate property, for example? What if there's violence, robbery, and murder? Absent an LLC, then maybe all of your assets or a lot of your assets potentially are subject to that creditor, right? You've got different protections in different states, and generally in Texas, for the most part, you may find some protections in your homestead. You may find some protections in some ERISA-based investments, maybe a 401k, IRA, inherited IRA. It gets complex, but just trying to give you some ideas to go and talk to your to research and talk to your attorney about. Employment taxes, you may be overpaying with an LLC. They actually can end up saving people on employment taxes potentially on their own records, but discuss that with your CPA. Do you want multiple LLCs or a single series LLC that has little children LLC underneath it? So we can discuss that if you want to call us and talk about that. Can you deed a property to an LLC if it still has debt, right? If you have a mortgage on a property and you deed it to an LLC, you may have just violated the mortgage clause, right? There's a assignment clause in most mortgages that says if you sell, assign, transfer your interest, then the mortgage is due and payable. Well, if you just transfer it to your LLC, that may trigger. And so you'd want to talk to your mortgage company about the ramifications if you actually transfer an asset to your LLC. And you need to weigh it against the cost of formation, loans, insurance, etc. For many people, LLC protection helps them sleep better at night, but it may not make the most sense in your situation. So you want to have that LLC discussion about your situation. Now, this is very important. An LLC at death. What happens to your LLC when you die? Well, if your LLC has to go through the probate process, which is very typical, then you may have to wait months or longer until the executor can make any LLC decisions. So what if no one can make payroll? Would you lose employees? Very, very likely. If you can't pay them, they're probably going to go. So all that stuff you built up, because now you're going to start losing clients potentially and lose the goodwill, all that value. And that could cost you 6 or 7 figures. A lot of people, their LLC is their number one or number two most valuable asset. So why would you want to risk it and try to just think, oh, it'll just take care of itself? Yeah, it may not. If you have a trust and you have the trust own that LLC, or the trust named as the beneficiary of that LLC upon your death, then the successor trustee can step in without having to wait on a court to give, approval to the executor 2, 3, 6, 12 months later, however long it may take to go through that probate. But start doing things right away. So let's have that LLC discussion or talk to your attorney. Legacy plan binder, what is it? It is one single consolidated and coordinated binder housing your important estate planning documents plus soft documents. It can be so helpful because you tell people where you store it. It houses the originals. You have pre-given e-copies to certain trusted individuals, maybe to your spouse, a couple of children, maybe all your children, some siblings, so that they have electronic copies that don't get burned up in a fire. Hard to misplace because they can always go and look at the folder they created under your name if something happens to you in a list. And it may even contain some soft information like your life goals, emergency numbers, love letters that you pre-wrote to each of your cherished loved ones. Go ahead and book a meeting if you're in Texas, bit.ly/Texas Lawyers Meetings, bit.ly/Texas Lawyers Meetings. And take a little bit of look about why Mike Massey Law, why you may want to consider booking a meeting with us. We have 5-star ratings. Your community has given us over 500 5-star ratings at this point in time, and you probably read, and maybe you read many of them. I'm actually going to come over here and grab something. All right, so let me just kind of walk you through a little bit about us so you get to understand Will's Trust and Estate Planning for Texans. We say, stop procrastinating. It's time. How to create a smooth transition plan for your entire life savings in just 3 short meetings with a flat fee and a law firm who has received over 500 five-star reviews. In fact, at the time of this recording, we have more five-star reviews on Yelp than any other law firm in Austin. Start to see a little bit about us. We have upfront and transparent pricing because you deserve that much. We simplify the complex because the more you understand, the better job we have done. Thousands of Texans have been served by our firm. Service with a smile. We service our clients with love and compassion, like you're part of our family. You know what? We're not the most expensive. We're neither the cheapest, because why would you want to cheap out on something so important? Nor are we the most expensive. No one wants to get taken advantage of. We offer free consults, and not just free consults, but free consult directly with an attorney before you hire us. We have a very smooth process that reduces stress and anxiety. Now, why would you want to choose us for estate planning? I'm going to skip over the ones we've talked to. Stress-free signing ceremony. Our signing ceremony takes the headache out of kitchen table signings. We have this awesome remain at home and incapacity care plan that talks about whether you prefer in-home care, even if costly. Let's put that in writing. Legacy plan binder. We'll service our clients with love and compassion like you're part of our family, but giving you a binder to house everything. We can actually make a legacy of love video for you to enhance your legacy with a long-lasting video. It's a gift that just keeps giving that you can hand down to the next generation. We'll show you how we think you should title all of your assets. We have timely turnaround. We generally deliver drafts in under 3 business days. We'll share an e-copy so that you can give electronic copies so that you can access them anytime, anywhere. A lot of attorneys actually don't share e-copies with their clients. We do. Stop procrastinating, right? We strive to eliminate your excuses so you can stop kicking the can down the road. Our process, a little bit what to expect. Step 1, we'll have a design meeting. That'll be to get to know you. We'll design what we think should be done. Step 2 is a review meeting. After we send the documents within 3 business days, then we'll have a review meeting, generally online via Zoom, to review all the documents. And then step 3, you'll just come in and sign them. And just like a surgeon typically does surgeries 1 day a week, we tend to do our surgeries 1 day a week. Right now, that day is presently Wednesday, but that could change over any point in time. And we also have a book that you can go and you can download. It's called Wills, Trust, and Estate Planning for Texans, Not Dummies. There's a picture of my family. Here's it's kind of cut off a little bit, but my wife of 19 years. My son is in 9th grade, Luke, and then Gracie, she's in 4th. Gabe is in 3rd. Ava is in 2nd. And little Mac, I call him Mac, is now 2 years old. And, I flew through those. We are almost done. So a will package, for example, would include a last will and testament, durable power of attorney, medical power of attorney, pre-need guardianship, HIPAA release, living will advance directive, final disposition instructions, asset titling instructions, 2 meetings to design and execute, an LLC discussion if you want, a home ownership discussion if you want, summary pages, 3-day turnaround of drafts typically, best steps to hopefully avoid probate. No one can be guaranteed to avoid probate because anything could trigger. There's a lot of things that could trigger probate, but we can set you up with the highest likelihood of avoiding probate presently at this point in time based on your situation. We'll talk about a discussion of a will versus a living trust and give you a legacy binder. So in 2019, we were actually rated one of the best law firms in America. They selected 10 best lawyers and law firms in 115 major cities, and we actually got that award. Avo, which is a lawyer site, a site to review and find out about attorneys. It's one of the most popular in the country. We have 5-star reviews, 90 reviews. They gave us the Client Choice Award 5-star in 2024, 2023, 2022, 2021, 2020. You get the idea. Yelp, you get an idea presently right now. So I'll just kind of show you here. On Yelp, we have 5-star reviews, 44 reviews. That's just phenomenal. And on Google, we have 233 reviews with a 5.0 rating, which is also just phenomenal. Thank you to our clients and our community for doing that. Here's the idea. Make sure your life savings goes to the right people at the right time rather than to the wrong people or to the right people at the wrong time. We're talking about your life savings and your legacy. Stop procrastinating. It's time. Go ahead and book a meeting. bit.ly/Texas lawyers meetings. bit.ly/Texas lawyers meetings. If you booked this, you're watching this online, social media or something, I would encourage you to like it, to share the link to your feed, share it with other people, to your parents, to your siblings, to your friends who you think may benefit from this. If you benefited, I bet there's people you know who could benefit. We're so thankful that you watched this. I hope it was incredibly helpful. And if you're in Texas and you end up hiring us, then we'd love to serve you. If you don't hire us or you're not in Texas, we just hope that you got a little information, at least one or two or three nuggets to take away and go and talk to your attorney or to do your planning to hopefully enhance your life savings plan. Because remember, it's your life savings and your legacy. Make sure it goes to the right people at the right time rather than to the wrong people or at the wrong time. Have a blessed day.